Welcome to the K&S Podcast series. My name is Gopinath, your host. This week we have with us Devi, partner with K&S Partners, one of India's leading intellectual property law firms. Good morning, Devi. Thank you for joining us.
Good morning, Gopinath. Thank you for having me. It is a pleasure to be here.
Today we are discussing an important recent decision of the Delhi High Court on the patentability of algorithms and computer-related inventions. The case is Kroll Information Assurance LLC versus the Controller General of Patents, Designs and Trademarks and others. Ms. Devi, to begin with, could you briefly explain what this case was about?
Certainly. The case concerned a patent application filed by Kroll Information Assurance. The invention related to a system, method, and apparatus for identifying sensitive or protected information on a peer-to-peer network. Broadly, the system used user-provided search terms to identify information and users who may be inadvertently sharing such protected information.
So at first glance, this sounds like a technology-driven invention. Why did the Patent Office reject the application?
The controller rejected the application on three main grounds. First, the controller found that the proposed claim amendments did not comply with Section 59 of the Patents Act. Second, the controller objected to the application for lack of inventive step under Section 21J. Third, and most importantly for this discussion, the controller held that the invention was not patentable under Section 3K, which excludes mathematical methods, business methods, algorithms, and computer programs per se from patentability.
That brings us to the central issue. Section 3K has been discussed quite often in the context of software patents and computer-related inventions. What exactly was the court examining here?
Exactly. The court referred to the Computer-Related Inventions Guidelines 2017. These guidelines require the controller to assess whether the claimed subject matter produces a technical effect or involves technical advancement. The key question is whether the invention solves a technical problem in a technical way or whether it merely automates an abstract idea using a computer.
Did the court accept any of those arguments?
The court accepted Kroll's argument on Section 59. It held that the proposed amendments were clarificatory and merely narrowed the scope of the claims. The court found that the amendments did not introduce new matter beyond what was already disclosed in the complete specification. Therefore, the rejection on that ground was considered erroneous.
But the court still upheld the refusal of the patent. Why?
Yes, because the court agreed with the controller on Section 3K. The court found that the claimed invention used generic and conventional computer hardware to connect to a peer-to-peer network and perform searches based on instructions provided by a user. The profiling feature was also considered abstract because it relied on keywords to locate relevant information or users. In the court's view, this did not transform the functionality of the hardware or produce a significant technical effect.
That sounds like the court was drawing a line between using a computer and improving the computer itself.
That is a good way to put it. The court relied on earlier decisions, including Lava, Microsoft, and BlackBerry, to clarify that algorithms or computer programs may be patentable if they result in a technical effect or advancement. For example, if implementation of the software improves the functioning of the hardware, enhances system performance, improves security at a technical level, reduces processing load, or produces another tangible technical benefit, the case for patentability becomes stronger.
But if the invention only uses a standard computer to carry out instructions, then it may fall under Section 3K?
Correct. Merely implementing an abstract process on a computer is not enough. The invention must go beyond normal computer functionality. In this case, the court held that the system behaved like a typical computer program. It searched, profiled, and identified information based on user-provided terms. That was not enough to show technical character or technical advancement.
That is a very useful point. Before we close, what would be your key takeaway from this decision?
The key takeaway is that computer-related inventions are not barred from patent protection in India merely because they involve software. However, algorithms and computer programs that lack technical effect remain non-patentable. Applicants must show that the invention solves a technical problem and produces a technical result. The more clearly this is brought out in the specification and claims, the stronger the application will be.
Thank you, Ms. Devi. That was a clear and practical explanation of a very important decision. This judgment seems especially relevant as more businesses develop software-led products, AI systems, cybersecurity tools, and data-driven platforms.
Thank you, Gopinath. Yes, it is certainly an important decision for innovators and patent applicants in the technology space.
And to our listeners, thank you for joining us on the K&S Podcast series. This discussion is intended for general informational purposes only and should not be treated as legal advice. For specific queries, please consult a qualified professional. We will be back soon with another discussion on developments in intellectual property law. Thank you for listening.